go ahead and signify with a reaction, raise your hand reaction button. That's the reaction button that's going to get you to the top of my screen. And then I'll take you up in the order that I see you. Well, let me just say we're on the docket for Monday morning, November the 8th, 2021. And Ms. Orellana?
Good morning, Your Honor. I have number 13 on your civil docket this morning.
Okay. And let me get that. That is CL 21-1927-I, Cruz Carizales Esquivel versus Texas Department of Transportation. Yes, ma'am.
Graciela Orellana for the plaintiff, Your Honor, and I believe Mr. Taylor Graham is in already as well.
Yes, Your Honor. This is Taylor Graham representing the defendant in that case, Texas Department of Transportation.
Okay, and what is the announcement, counselors?
Your Honor, on this one, it's a fairly new case. We're just about finishing discovery on this one. We're still pending depots and mediation to work on, but we've been working well together. The lawsuit was just filed not too long ago.
That's correct, Your Honor.
Okay, so you're just getting started with everything then, right?
That's correct, Your Honor.
Okay. All right, well, why don't y'all come back on March the 2nd? And let's see how far you've been able to get in about 90 days or so.
At the same time, Your Honor, 9:30?
Yes, ma'am.
Okay, I have nothing further. May I be excused?
Yes. Mr. Graham, do you have another case?
No, Your Honor. This is my only one. May I be excused as well?
Yes, sir. Y'all have a good one.
Thank you. You too.
Okay, Ms. Rodriguez?
Good morning, Judge. I'm here on number 5.
CO 190754-I, Brian Esparza versus Olga Calvo et al.
Danielle Rodriguez for the plaintiff, Brian Esparza. We're set for a hearing on defendant's motion for no evidence summary judgment. We filed a Rule 11 on Friday passing the hearing, so I'm not sure if the court has it noted.
Your Honor, if I may.
Yes.
Okay, there was a Rule 11 filed, but there is no order resetting, and the link does state that a status hearing given by the court, they're not to be reset.
Okay, so it said on status hearings, the reason that I don't like for them to be passed is because then I lose you all. And I don't know, I just need somebody just to pop on and let me know what's going on, you know, and then I'll be the judge of whether or not, no pun intended, okay, as to whether or not we're gonna need to do anything further on the case. That's the only reason why status hearings, I won't accept Rule 11s. But you're not on a status, you're on a motion for no evidence, right?
Right.
Okay, then you would need an order resetting hearing to accompany any Rule 11, and then I'll pass it.
Okay.
Judge, if I may also, you had already given a previous status hearing for January, and then they filed their motions, and they were set for today, and then they filed the Rule 11, but they're already set for a status in January.
Yeah, but they're gonna reset the summary judgment motion. Is that what I'm understanding, Ms. Rodriguez?
Right. It's not my motion, but
Okay.
the defendant decided to pass the hearing.
Okay, so are you all substituting in for Mr. Solis, or you were?
He's our co-counsel.
Oh, okay. I just wanted to make sure. And Mr. Tijerina is still on for the defense?
Yes, there's 2 defendants, so he represents one. He wasn't part of the motion for summary judgment.
Oh, okay.
That was filed by Daniel Vargas.
Okay, can you please let them know that they have to have their order resetting hearing filed by Friday?
Okay.
And that's more than enough time.
Okay.
Because it's their motion, right? It's not yours, so.
It's Daniel Vargas's motion.
Okay, well, Mr. Vargas needs to file his order resetting hearing before Friday.
Okay.
If not, we're not gonna hear it. We'll just hear you at the status in January.
Okay.
All right? Okay, anything else?
No, Judge, may I be excused?
Yes. All right, Mr. Salinas? Mr. Salinas, can you hear me?
Yes, Judge. Yes, Judge. Good morning.
Good morning.
Judge, I have a divorce case. I believe it's number 4 on your docket.
Okay, F 2405-19-9 in the matter of the marriage of Hector Garcia and Cassandra Garcia.
Yes, Judge. I'm not sure if Mr. Morales is on yet, Judge. He's the lawyer for the petitioner in this case.
Okay, and are we proving it up today?
Actually, Judge, we were ordered to mediate this case. We have not done it, so we're asking for that opportunity to. And it was already, that order was already signed by the court to have this case mediated. We haven't done it, so we'd like to have that opportunity to do that.
What happened? Scheduling conflicts or what?
I imagine, Judge. I'm not sure what happened.
Who are you all supposed to mediate with?
Judge, I'm not sure. I was having some difficulty getting onto the special website this morning, and I'm not sure who the mediator was.
Okay, can my staff let me know who's assigned to mediate this case?
Yes, Judge. Judge, on March the 9th of this year, the order was signed by a court or by the court ordering mediation. And I'm not sure who the, let me see, mediator was Kathy Alvarado. Judge.
Okay, well, that's a rather long time to not be able to schedule mediation in 8 months.
I'm not sure, Judge. I just know that in August, I was out with COVID for a whole month, Judge, so.
No, I understand. Well, let them see what you can do about getting this mediated. Do they have children?
Yes, Judge, there's one child.
Okay, because you know that the holidays always bring out the best in everyone, so.
Yeah.
You're gonna have some issues, you know what I mean? So let's try to see if we can get that mediated soon. And I'll go ahead and I'll have you come back on January the 26th, and that's plenty of time. So I'm gonna hold over for a final hearing on January the 26th. And if y'all aren't ready, let us know.
Thank you, Judge.
And it'll be at 9:30.
Thank you, Your Honor.
All right, thank you.
Yes, Judge.
Okay, any other quick announcements? Okay, Mr. Dominguez.
Yes, Your Honor. We're here on, Mr. Peña is online also. And we're here on number 11.
Good morning, Your Honor.
Good morning, sir. All right, CL 141937-I, Maria Trevino et al. Versus Ricardo Garza Gonzalez. And what is the announcement?
Well, I believe it was set for a status hearing this morning. I'm brand new to the case. I just filed an answer for the defendants last week. And I found out last week about the status hearing today. And we just filed the answer. I was informing Mr. Peña last week. We spoke on the phone. And I told him that under the new discovery rules that we have to provide disclosures to each other before we can send out any interrogatories or requests for production. And we agreed to do so, I believe.
We have agreed.
So I will be sending my disclosures to Mr. Peña. He will send his to me, and then we will begin with interrogatories and requests for production. This is obviously an old case that was transferred to this court from County Court 6, and it looks like nothing much happened for several years. And so I don't know the actual facts of the case, but I figure we'll find out in discovery.
It was delayed simply because defendants had no counsel. Now they're fortunate to have counsel, Mr. Dominguez. So we're ready to proceed, Your Honor, as per the rules.
Okay, well, I'll give you some time to work up the case. Let's come back on March the 2nd and see how far you've been able to come on it.
Is that another status hearing?
Yes,
All right.
and that'll be March 2nd at 9:30.
Thank you very much, Your Honor.
Thank you, Judge. May be excused.
Yes, thank you.
Thank you.
Okay, Mr. Morales. Mr. Salinas made the announcement on the divorce case that you all have. He did announce that mediation had not occurred. I did let him know that since the order had been already out for 8 months, I would have expected that it would have occurred by now. However, I'm going to give you all an opportunity to come back on January the 26th at 9:30, and hopefully it'll be to prove up the divorce. If you all
Okay.
get that divorce, that mediation done sooner and need a prove up hearing sooner, just make sure, please, that you get it done before December 15th, because that'll be the last date that I will be hearing civil matters this year.
Okay, Judge, and you said January 26th, right?
Yes, at 9:30.
Okay. We'll do that, Judge. Thank you.
Okay. Thank you. All right, Mr. Ramirez, Ricardo Ramirez.
Good morning, Judge. I have number 8 on the court civil docket.
Okay, that's F1906-21-9 in Ray of Elizabeth, I'm sorry, Chiao, CHIO, and it's a hearing on a name change.
Yes, Judge, she filed her petition, the affidavit of prove up and the order pro se back in April 23rd. So we're ready. I can ask some questions to prove up the affidavit.
Okay, hold on. All right, so let me double check on this. Okay, so she does have the criminal history on file from the Texas Department of Public Safety, correct?
Yes, Judge.
Okay. All right, and I do see that that has been on file with the court back on August 20th, 2021. Okay, then we can proceed because the required documents are on file and they have been on file for the required number of time. So is your client present?
She's present, Judge. She's here in my office, sitting
Okay.
to my right.
All right, ma'am. Will you please raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You need to speak up.
Yes.
Okay, you may lower your hand. Okay, Mr. Ramirez, you can proceed with the questions.
Thank you, Judge. Ma'am, what is your current legal name?
Okay, she needs to, I can't hear her at all. That means my court reporter can't hear her. She needs to get closer to the microphone and speak up loudly.
And what is your current legal name?
Elizabeth Angles Chio.
And you're asking the court to change your name to?
Yes.
What's the name?
Elizabeth Angles.
I
How old are you?
I can't hear Judge.
Yeah, we still can't hear her.
Okay.
I can hear you. I can hear you. So either she's speaking softly or.
Let me switch. Let me switch seats with her, Judge. It might be-
Okay.
All right. Now, what is your current legal name?
Elizabeth Angles Chio.
And you are asking the court to change your name to what?
Elizabeth Angles,
How old are you today?
39.
And are you competent to testify about the contents of your petition for the name change?
Yes,
And are the facts that you're stating today are within your personal knowledge and are true and correct? Are the facts that you're stating today true and correct?
yes,
And you're not asking the court to change your name to avoid criminal prosecution?
no,
You're not asking the court to change your name to avoid the payment of debt?
no.
What is your home address?
1600 West McAllen, Nolana, McAllen, Texas, 78504.
And the social security number listed on the orders you submitted to the court is correct?
Yes,
And the driver's license you submitted to the court on the orders is correct and has been issued to you for the past 10 years?
yes,
And do you have an FBI or an SID number?
no,
And have you ever been charged with a class A or B misdemeanor or felony?
no,
Have you ever been convicted of a felony?
no,
Are you required to register as a sex offender?
no.
All right, Judge, the petition for the name change it includes a legible and complete form of the fingerprints. And at this time, we believe the name change is in the best interest and benefit of the client and the interest of the public. And we ask the court to grant the name change from Elizabeth Angles Chio to Elizabeth Angles. That's all I have.
Okay, ma'am, and the reason for the name change is because of your divorce. Chio was your former name while you were married?
Yes,
Okay. The court will take judicial notice of all the documents in the court's file and will grant the name change. So just get an order on file and I will have that forwarded to my queue. And that way she can get her certified copies to get her license and her social security all changed.
That's all we
Okay,
have to do, Judge. We didn't-
all right. Do you have your order on file?
Yeah, the order was submitted, Judge, back on April 23rd, and it was it's one of those TexasMallHelp.org orders that was filled out by PIN. That's on the court's file. I'm happy to submit another one.
Yeah, you'll need to submit another order with your signature approving it.
Very well.
And then that way, it's a better order than the one that was filed previously. Okay, all right, so I'm gonna set a tickler for November the 19th, just to make sure that it's been submitted by that time.
Okay, we'll get it out sooner than that. Thank you.
Okay. All right, thank you. Y'all have a good day. Okay, Miss Restifo?
Good morning, Your Honor.
Good
I'm
morning.
here on number 7 on the docket.
F0975-21-9 in the matter of the marriage of Lilia Valdez and Abraham Valdez.
Yes, ma'am. I believe this is just going to be a prove up. He filed a global waiver of service.
Okay. And are we still consolidating into, was there a previous case?
There was an OAG case pending, but they've since non-suited that case, and I spoke to them. They're not intervening in this case.
Okay. All right. And so Miss Valadez, is she present?
She is, Your Honor.
Okay. And so Mr. Valadez is not going to be present because he signed a waiver.
Yes, I believe it was filed with the court on October 1st of this year.
Okay, give me one moment. Okay. So Ms. Valadez, will you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may proceed.
Thank you, Your Honor. Can you please state your legal name for the record?
Lilia Garcia Valadez.
And are you the petitioner in this case?
I am.
And are you currently married to Abraham Valadez, the respondent?
I am.
And immediately before filing this suit for divorce, did you live in Hidalgo County for 90 days in the state of Texas for 6 months?
Yes.
And Your Honor, we're just asking the court to take judicial notice of the waiver that's been on file since October 1st.
The court will take judicial notice of all the documents that are in the court's file, specifically the waiver of service that has been on file for the required amount of time. Go ahead.
Thank you. And you and your spouse married on October 13th, 2017 and separated on October 11th of 2020, is that correct?
Yes.
And the reason for the separation was domestic violence?
Yes.
And you're asking for a divorce based on cruelty?
Yes.
And you have one child of the marriage, is that correct?
Yes.
And can you state his name and age?
Axel King Valadez, 6 years old.
And are there any other children expected at this time?
None.
And you and your spouse never adopted any children?
No.
And there are currently no orders in place for your child, is that correct?
No.
And you're asking that the court appoint you sole managing conservator and your spouse have supervised visitation?
Yes.
And the visitation schedule you're requesting is every first and third Saturday from 9 a.m. to 6 p.m. and then the immediately following Sunday also from 9 a.m. to 6 p.m.
Yes.
Okay. And Mr. Valadez will also have visitation on Father's Day from 9 a.m. to 6 p.m.
Yes.
And he'll also have summer visitation from June 15th at 6 p.m. till June 30th at 6 p.m.
Yes.
And you're asking that all visitations be supervised by his mother, Salmoneta Valadez, or his sister, Macarena Valadez Pena, or a competent adult designated by you. Is that correct?
Yes.
And you're asking that he give you 24 hours written notice if he's exercising his visitation?
Yes.
And you're also asking that he be prohibited from using drugs or alcohol 24 hours prior to his visitation or during his visitation. Is that also correct?
Yes.
And you believe these orders are in the best interest of your child?
Yes.
And you currently have a protective order in effect, is that correct?
Yes.
And that has a finding of family violence from this court?
Yes.
And so I just briefly want to discuss some of the violence that has occurred. In 2017, your spouse attacked you with a pair of scissors, is that correct?
Yes.
And he was charged with aggravated assault with a deadly weapon?
Yes.
And he pled guilty to that?
Yes.
And in 2019, your spouse was intoxicated and punched you twice, is that correct?
Yes.
And also in 2019, he grabbed you by the hair and dragged you. He busted your face up.
Okay, Ms. Restipo, the guy, since he already pled guilty to that one charge, I understand. I don't want to reliving I'll acknowledge that, and I will take her testimony that he was violent with her. And that I know she's already getting emotional and I'm not going to have her relive it. I understand what you're trying to do. However, if he pled guilty to a violent charge already, so that's enough to go ahead and substantiate her pleadings that are on file, and I don't want to have to relive it here on the record and in YouTube. So you can go ahead and I'll acknowledge that has occurred.
No problem, Your Honor. I just was trying to make a clear record for.
Yes, I understand. But what helps you too is that he signed a waiver and he said that I could take it up without any notice to him, and he's not going to sign off on the decree. And so, but I totally understand why you're doing it. But it's sufficient for the court that he pled guilty and he was convicted of that crime. and it was a violent crime that would be considered domestic violence. So I'm good with that. So you can go ahead and get to the part of how are we dividing the property and what are we doing as far as child support and healthcare.
Yes, Your Honor, I'll move on. Thank you.
Thank you.
So child support, you're asking that child support be based on a minimum wage, is that correct?
Yes.
And that would be $227.89 and 89
Yes.
cents. However, your
Yes.
son is receiving Social Security benefits based on Mr. Valadez's Social Security disability benefits, is that correct?
Yes.
Okay. And the amount of that is $349.
Yes.
And you're asking that his child support obligation be offset by that derivative benefit, is that correct?
Yes.
And you're not asking for retroactive child support?
No.
And your child is on Medicaid, is that correct?
Yes.
And you're asking that Mr. Valadez pay $50 a month in medical support?
Yes.
And you believe that those orders are in the best interest of your son?
Yes.
And you and your spouse have not accumulated any community property, is that correct? Besides for personal effects?
None.
And you're just asking the court award you personal items that are in your possession and the court award him personal items that are in his possession, is that correct?
Yes.
And likewise, you're just asking that the court award you any debts that are in your name and award him any debts that are in his name?
Yes.
And you are asking for a name change, is that correct?
Yes.
And can you state for the record what you would like your name changed to?
Lilia Garcia.
And you're also asking that the court grant the permanent injunction that you pled for?
Yes.
And you're asking that the court grant your divorce?
Yes.
Your Honor, I just ask that the court admit the petitioner's amended exhibits. It's a copy of the protective order is P1. P2 is Mr. Valadez's indictment in the aggravated assault case. P3 is the judgment, and P4 is photos of Mrs. Valadez's injuries.
That'll be admitted.
Thank you, Your Honor. I have nothing further.
Okay. And Ms. Valadez, has his mom and sister agreed to supervise?
Yes.
Okay. Okay, then the court will grant the relief as requested and testified to on the record by Ms. Valadez. Will further take judicial notice of all the documents in the court's file, not only the waiver of service, but also plaintiff's exhibits that have been admitted and are now part of this case. And will grant your name change to Lilia Garcia. And how much time do you need in order to get that divorce decree to the court?
I'll be submitting it as soon as we get off here.
Okay. All right, then go ahead and get that submitted, and I'll ask that to be forwarded to my queue. Best of luck to you, Ms. Garcia.
Thank you so much, Judge.
Okay.
Thank you, Ms. Restrepo.
Thank you, Your Honor. I have nothing further. May I be excused also?
Yes, ma'am.
Thank you.
Thank you. Okay, Mr. Alvarez, Oscar Alvarez.
Good morning, Your Honor.
Good morning, sir. What case number?
I've got number 9 on your docket. It's a petition for occupational driver's license.
Okay, CO 21-3580-I. Is Mr. Barra on?
He is present here in my office, Your Honor.
Okay. And good morning, sir. All right, Mr. Barra, let me just make sure that I have my ADAs on. Mr. Lozano, Mr. Sosa, who will be taking up this occupational license hearing?
Me?
No. I need from the state. Mr. Lozano, Mr. Sosa, can y'all hear me? Let me have my staff contact them to make sure that I'll recall you as soon as they get back on, Mr. Alvarez. It shouldn't be long. They probably stepped away from their computer.
Very well.
Okay, just be on standby, Mr. Barra. I'll take you up right now. All right, Mr. Fuganti, or I'm so sorry for mispronouncing your last name.
It's Fuganti, Your Honor.
Okay, And what number on the court's docket, sir?
It's CL 21-24361, Oliphant Financial against Jorge Miranda.
Number 6, Your Honor.
Okay, and what is your announcement, counselor?
There's actually a motion, 106 motion. On this case, we have found it's a gated community.
Oh.
But the person doing the service already confirmed that the car that's every time parked in front of the house, it's registered to the defendant, and everything indicates that the defendant lives in that address. We just cannot reach him in person.
Okay. And the alternative address at 1002 West Dove Avenue in Pharr, Texas is what building, sir?
Let me just check here the service package, Your Honor.
Okay, so it says that it's gated and locked. I believe according to your affidavit, it says that that address is gated and locked. The defendant does reside at the address, but is not at home, as per the wife. And I believe you tried 7 times.
Yes, we tried several times. We don't usually ask likely for this type of motion, Your Honor.
Okay, so then you're asking that if they're able to make it through the gates, then just to attach it to his door.
Yes, Your Honor.
Okay. The court will take judicial notice of all the documents in the court's file related to the motion for alternative service, which is a Rule 106B motion, and specifically the affidavit that was filed by the civil process server, Gilberto Cantu Jr., and his attempt of 7 times with specific detail as to each time that he went out there and the defendant was either not present or they could not get to the location. So the court will grant your motion for substitute service. And I do see that you have an order on file. So I'll ask for that order to be forwarded to us.
Thank you, Your Honor.
Okay, sir. Anything else?
No, that's all on my only case for today. May I have a
Okay. All right. Thank you. Yes, you may be dismissed.
Thank you. Have a good day.
Likewise. Okay, Mr. Lozano or Mr. Sosa, did you come back on? Was my staff able to contact Mr. Lozano or Mr. Sosa?
Yes, ma'am. I spoke with Mr. Sosa. He advised he was going to be turning his camera on.
Okay, then I'll just wait for him. Okay, Ms. Galvan, Monica Galvan.
Yes, Your Honor, I have number 12 on the court's docket.
All right, CL 20-0050-I, Norma Richmond versus Elgins, ELGINZ Investments. And what is the announcement, counselor?
Your Honor, we need another status hearing. We are trying to work this case out.
Okay, have you all attended formal mediation yet?
No, Your Honor. If you would give us an opportunity to send the defense, they've asked for a demand on this case, see if we can settle it before we go to mediation.
Okay, and how much time are you requesting?
Your Honor, 60 days if possible.
Okay, I'll have you come back on January 26th.
Thank you. May I be excused?
Yes, and that'll be at 9:30.
I appreciate it. Thank you, Judge. Have a good day.
Okay, Mr. Sosa, Mr. Alvarez is here on number 9 on the court's docket. It's an occupational license hearing. Let me give you the clause number so you can pull it up.
Okay, Judge.
It's CL -21-3580-I.
CL 213580-I.
Yes, and it's the state of Texas versus Epifanio Perez Barra.
Okay, Judge, I apologize. We didn't receive notice. I'm assuming it was on the docket that was sent on in the morning, but we don't have, we didn't have an order setting hearing or really anything when I pulled it up on my email.
Okay.
I apologize for any inconvenience. Would there be any way we can receive a reset on this and take care of it on the next available docket?
Okay, I can see why you didn't receive notice. It was sent to the previous ADA.
Okay.
So, Mr. Alvarez, the order setting hearing, since it was filed prior to the change in the ADAs for our court, it was sent to the previous ADA. And so my current ADAs do not have notice of today's hearing, so we're not able to review the case. I can bring you back very quickly on the, let me see.
Calendar.
I can have you come back on the 17th at 9:30.
Let me look at my calendar.
Okay.
Who will be handling this case for the?
Now it would be Eduardo Sosa or Adrian Lozano.
And who's present today? So, Mr. Sosa?
Myself, yes, sir.
Yes.
Judge, I will just share something with Mr. Sosa so he can look into this, because this was an issue that I discussed with the previous ADA. Mr. Perez was arrested in Cleburne County, but was not convicted. He was placed on pretrial diversion, and it was the position of the assistant district attorney previously that this petition had to be filed in Cleburne County. But I suggested to him that the statute states that he can file in his own county, the county where he resides, as long as he has not been convicted. So he has not been convicted in Cleburne County.
Hold on, I'm sorry, somebody's.
My apologies, sir. Where was the arrest again?
The arrest was in Cleburne County, but he was not convicted. He was placed on pretrial diversion, and I believe the statute.
I'm sorry, that was Kleber. I've never heard of that county. My apologies.
Yeah, Kleberg County, Kleberg County.
Thank you, Judge.
Yes.
So if there's a question, you may want to call me at the office prior to the hearing so we can iron that out.
Sure, I'll give you a call right now, Mr. Alvarez. What's a good number for you if you don't mind putting it on the record?
686-6330.
686-6330. Got it, sir. Okay, I'll give you a call so we can discuss. I just need to go over our checklist. Sometimes we have to do, a background check and things like that. Otherwise, I would have been happy to take care of this today. So, my apologies for any latency or tardiness on this.
Very well. The 17th is fine, Your Honor. At what time was that, at 9:30?
Yes.
Thank you.
Okay, so we'll come back on that date and we'll get it taken care of.
Thank you, Your Honor.
Okay. All right, you may be excused. We'll see you on that day, Mr. Barra.
Okay, thank you.
Thank you, sir. Okay, Mr. Ramirez, Dennis Ramirez.
Sí, el mismo tiempo.
Gracias.
Good morning, Judge.
Buenos días.
Good morning,
Morning,
sir.
Judge.
Okay, Mr. Ramirez, who are the parties in this matter?
Your Honor, Dennis Ramirez on behalf of the petitioner, Derek De Los Rios.
And who is the respondent?
The respondent is Maria Eugenia Valdez Lopez. I can see that she is logged on the screen.
Okay, I'm sorry. What name? What's her name?
Maria Eugenia Valdez Lopez.
And Miss Lopez is Spanish speaking?
Yes, Your Honor.
Yeah.
Okay. So just to let you know that it's the court's policy on contested matters. If it's going to be a contested hearing where you're going to have, testimony from both sides, then an interpreter needs to be provided by the person that's requesting the hearing. However, I do see it's a show cause hearing where we're trying to find out according to the pleadings, that with respect to visitation of the children or the lack of visitation.
Correct, Judge.
Okay, so Ms. Castañeda, please let her know that we're here on this hearing according to the pleadings on file, that we're trying to find out as to the lack of visitation of the children with the father.
Ms. Valdés López, estamos hoy en esta corte para los alegatos que están archivados tocante las faltas de visitas de los niños que han tenido.
Sí.
Yes.
Okay. So, yes.
Primeramente, mi nombre es María Eugenia Valadez López y el nombre de mi hijo completo es Derek Lee de los Ríos II. Y yo en ningún momento me he negado a la visita, a que el papá de mis hijos lo visite.
Okay, hold on. Let her know that if she's going to be talking, she needs to do it slowly because you're going to be translating.
Ms. Valdés López, si va a estar hablando, necesita ir despacio porque necesito traducir.
Sí.
And tell her that whoever's talking to her in the background needs to get out of the room because I can hear them, or they need to be quiet.
La persona que está con usted en el cuarto tiene que salirse del cuarto o se tiene que mantener callado.
Okay.
Okay.
All right, so what I'm gonna do, Mr. Ramirez, is I'm gonna, first let me ask her if she's going to get counsel, okay?
Yeah.
And then, because I do have some other matters that I do need to take up as well. So Ms. Castañeda, please ask her if she intends on getting representation for this matter.
Ms. Valdés López, ¿va usted a contratar un abogado que la represente?
Sí.
Yes.
Ask her how much time is she requesting to do that?
¿Cuánto tiempo necesita para hacer eso?
Un mes.
A month?
No, because she's not, if there are issues with the children not visiting the father, I know she says no. Dad says yes. So I'm gonna make my own conclusion.
Okay, porque dicen que hay problemas con las visitaciones, usted dice que no, el papá dice que sí, yo voy a hacer mi propia conclusión.
And we have Thanksgiving that's coming up.
Y viene el Día de Acción de Gracias.
And then we have Christmas that's coming up.
Luego tenemos Navidad.
So something needs to be done before the holidays.
Algo necesita hacerse antes de los días de vacaciones, de los holidays.
So if she wants the 30 days, the only way I'm going to do that is if I have something in writing saying what is going to happen with those children.
So, si está pidiendo 30 días, necesito algo escrito que va a pasar con los niños.
If not, then I will see her here on November the 17th at 11 a.m. with counsel.
Si no, entonces la próxima corte va a ser el 17 a las 11 de la mañana con su abogado presente.
I will, however, if she wants to represent herself, which I never recommend, but
si usted se quiere representar sola,
then before any temporary orders hearing, it is always a requirement of the court for them to mediate the matter.
Antes de cualquier orden que haya de temporales, órdenes temporales, yo requiero que vayan a mediación.
So what does she want to do?
So, ¿qué quiere hacer?
No cuentan con abogados un abogado que me puedan ustedes brindar o algo para que sea
Do we have an attorney that you can give me?
We do not appoint attorneys for family cases or civil cases.
A la corte no apunta abogados para casos familiares.
We only appoint them on family cases when jail time is, when the person is facing jail time, such as for an enforcement or contempt action.
El único tiempo que pone la corte para abogado en casos familiares es cuando la otra persona está enfrentando cárcel.
So, but not in cases like this.
Pero no en casos como este.
Okay.
Okay.
So, she needs to see what she can do by that date. If not, you know, or if she wants to try to work something out, she can talk to Mr. Ramirez.
Okay. Necesita ver qué va a hacer para ese día o si quiere hallar una conclusión necesita usted hablar con el señor Dennis Ramírez.
Okay, está bien.
Okay.
Mr. Ramirez, are there orders already on file for this case?
No, Your Honor, it's an original STAPSR. And as an officer of the court, I did attempt to resolve all matters with the prior to filing. And she did advise me she did not want to cooperate and that I would need to serve her with the documents.
Okay. Let her know that Mr. Ramirez just stated that he did try to work something out with her, but she stated that she would have to be served. So now here she is, and we need to deal with it because it's in my court now.
Ok, el señor Ramírez acaba de decir que él trató de resolver algo con usted y usted dijo que la tenían que servir. So aquí estamos.
Sí.
Yes.
All right. So now if she's going to be, for the time being, if she's representing herself, then she needs to speak with Mr. Ramirez.
Por ahora, como usted se está representando sola, usted tiene que hablar con el señor Ramírez.
Okay.
Okay.
And Your Honor, for the record, I will be filing an order resetting this hearing. And if I could just get a good email address for her so I can communicate with her in writing.
Sure. Ms. Castaneda, please ask her for her email address.
Ms. Valdez López, por favor, me da su correo electrónico.
Sí, es María con Y. Eugenia. 147 @gmail.com.
Que son María se espela M-A-R-Y-A.
Es María con la Y. Sí.
Okay. It's MARYAEUGENIA 147 @gmail.com.
Yes. Sí.
Okay, so we'll see you back here November 17th at 11 a.m.
Thank you, Judge. May my client and I be excused?
Yes, sir.
Thank you.
Okay, Deputy, I'm sorry. Yes, sir.
Okay, Judge, we have to be at the 92nd in this section at 11 o'clock. Is there any way I can log out and try to find a different section?
No, bring him in. We'll take him right now.
Thank you. Thank you, ma'am.
Mr. Oxford, you're here for Mr. Canales?
Correct, Judge. Thank you very much, Judge.
Absolutely. All right. Mr. Sosa, are we ready?
Yes, Judge, we're ready.
Okay, and Mr. Oxford, we're going to be taking up, let me see, 1, 2, 3.
Judge.
So he's playing out on all his cases, is that correct?
That's correct. He's already pled on the felonies, and so it's just a matter of getting these pled to, Judge.
All right.
Well, Judge, if I may, we're going to be
Yes.
dismissing 2 cases.
Which are the 2 that you're dismissing?
That's going to be CR 20-00626I, as well as CR 21-05-363I.
Okay, and those are being dismissed with a plea to what? All of them?
All of the other cases, Judge. It's going to be eight total cases.
All right. Okay, Mr. Quintana, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Okay. In the state of Texas versus Joel Quintana Jr., is that your true and correct name, sir? And you are before the court charged with driving while intoxicated, a Class B misdemeanor, possession of a controlled substance, penalty group 2A of less than 2 ounces, a Class B misdemeanor, Another charge of possession of controlled substance, penalty group 2A, less than 2 ounces, a Class B misdemeanor. Possession of a controlled substance, penalty group 3 of less than 28 grams, a Class A misdemeanor. Driving while intoxicated, a Class B misdemeanor. Possession of a controlled substance, penalty group 2A, less than 2 ounces, Class B misdemeanor. Possession of, I'm sorry, you're dismissing that one. Possession of controlled substance, penalty group 2A, less than 2 ounces, and possession of controlled substance, penalty group 3 of less than 28 grams. On the offenses of which you are charged that are Class B misdemeanor, those carry a potential penalty of up to 6 months in Hidalgo County Jail and up to a $2,000 fine upon conviction. For those cases that were Class A misdemeanor of which you are charged, those carry a potential penalty of up to 1 year in Hidalgo County Jail and up to a $4,000 fine upon conviction. Do you understand the range of punishment that you can receive for the offenses of which you are charged?
Yes, ma'am.
Can you speak up a little bit louder, please?
Yes, ma'am.
Okay. And you have a right to an attorney and a right to a trial by jury. You can waive one or both of those rights by signing a written document with the court. Did you have an opportunity to review the document with your attorney before signing it? Yes or no?
Yes, ma'am.
Did you understand that when you signed those documents, you were waiving your right to a trial by jury? Yes or no?
Yes, ma'am.
Then the court will accept your waiver of trial by jury. Has any court ever declared you to be mentally incompetent, crazy, or insane?
No, ma'am.
And Mr. Oxford, in speaking with your client, do you find him to be mentally competent and able to assist you in his own defense?
He is and he can, Judge.
Then the court will make a finding that Mr. Quintana is mentally competent, able to assist his attorneys in his own defense. Do you understand, Mr. Quintana, that if the punishment I assess does not exceed what's recommended by the state, you'll need this court's permission if you decide to file an appeal? Yes or no? Do you understand that?
Yes, ma'am.
Okay. Now, and do you further understand that I do not have to accept the state's recommendation?
Yes, ma'am.
Are you a US citizen?
Yes, ma'am.
Okay. Then in CR 1814567-I, the state of Texas versus Joel Quintana Jr. for the offense of driving while intoxicated, a Class B misdemeanor. How do you plead, sir? Guilty or not guilty?
Guilty.
In CR 1814568-I, state of Texas versus Joel Quintana Jr. for the offense of possession of controlled substance, penalty group 2A of less or equal to 2 ounces, a Class B misdemeanor, sir. How do you plead? Guilty or not guilty?
Guilty.
In CR 1902109-I, state of Texas versus Joel Quintana Jr. for possession of controlled substance, penalty group 2A of less or equal to 2 ounces, a Class B misdemeanor, sir. How do you plead? Guilty or not guilty? In CR 1910964-I, the state of Texas versus Joel Quintana Jr. for possession of controlled substance, a penalty group 3 of less than 28 grams, a Class A misdemeanor, sir. How do you plead? Guilty or not guilty?
Guilty.
In CR 1910965-I, the state of Texas versus Joel Quintana Jr. to the offense of driving while intoxicated, a Class B misdemeanor, sir. How do you plead? Guilty or not guilty?
Guilty.
In CR 200625-I, the state of Texas versus Joel Quintana Jr. for possession of controlled substance, penalty group 2A of less or equal to 2 ounces, a Class B misdemeanor, sir. How do you plead? Guilty or not guilty?
Guilty.
In CR 2105362-I, state of Texas versus Joel Quintana Jr. possession of controlled substance, penalty group 2A of less or equal to 2 ounces, a Class B misdemeanor, sir. How do you plead? Guilty or not guilty? In CR 2105363-I, the state of Texas versus Joel Quintana Jr. for possession of controlled substance for penalty group 3 of less than 28 grams, a Class A misdemeanor, sir. How do you plead? Guilty or not guilty?
Guilty.
And are you pleading guilty freely and voluntarily?
Ma'am.
I'm sorry, that cut off. Yes or no?
Yes, ma'am.
And the court will accept your pleas as being freely and voluntarily given. I will call for state's evidence at this time.
Yes, Judge. State offers plea documents and offense reports as State's Exhibit 1, notification and certification of defendant's right of appeal as State's Exhibit 2, waiver of Article 39.14 disclosures as State's Exhibit 3, and waiver of risks and needs assessment as State's Exhibit 4. State would request defense counsel stipulate to venue and jurisdiction of this honorable court. Further, state would request defense counsel stipulate to the fact that all evidence which has been e-filed is sufficient to corroborate today's plea.
Okay, and any objections?
Actually, so agreed and stipulated, Judge.
There being no objections from defense counsels to exhibits, the exhibits are hereby admitted and approved. Therefore, in CR 1814567-I, it is the judgment of the court, sir, that you are guilty as charged. In CR 1814568-I, State of Texas versus Joel Quintana Jr., it is the judgment of the court, sir, that you are guilty as charged. In CR 1902109-I, State of Texas versus Joel Quintana, it is a judgment of the court, sir, that you are guilty as charged. In CR 1910964-I, State of Texas versus Joel Quintana Jr., it is a judgment of the court, sir, that you are guilty as charged. In CR 1910965-I, State of Texas versus Joel Quintana Jr., it is a judgment of the court, sir, that you are guilty as charged. In CR 2000625-I, in the State of Texas versus Joel Quintana Jr., it is a judgment of the court, sir, that you are guilty as charged. In CR 2105362-I, the State of Texas versus Joel Quintana Jr., it is a judgment of the court, sir, that you are guilty as charged. In CR 2105363-I, in the State of Texas versus Joel Quintana Jr., it is a judgment of the court, sir, that you are guilty as charged. What is the state's recommendation?
Yes, Judge. My apologies, Judge. They're all time served recommendations, Judge. However, two of the cases, the 21 cases we're pleading them out to, have 46 days. Hidalgo County Jail credit for 46 days. The other 6 cases, one 2020 case, 3 19 cases, and 2 18 cases are 45 for 45. So the state's recommendations are as follows: for CR 18-14-567, CR 18-14-568, CR 19-02-109, CR 19-109-64, CR 19-109-65, and CR 20-00625. The state respectfully recommends a $100 fine plus court costs plus 45 days Hidalgo County Jail credit for 45 days. And on CR 21-05361I and CR 21-05362I, the state respectfully recommends a $100 fine plus court costs plus 46 days Hidalgo County Jail credit time served for 46 days. Judge.
Okay, Mr. Oxford, any questions or requests on behalf of your client?
Yes, Judge. My client's going to be going to SafeP shortly. So we would ask for any consideration on the fine and court costs in all cases, Judge.
He's going where, I'm sorry?
SafeP.
Oh. Okay. The court will waive Mr. Quintana's fines and court costs and will follow the recommendation of the state. Okay, anything else, Mr. Oxford?
Nothing from the defense, Judge.
Okay, anything from the state?
Nothing from the state, Your Honor.
Okay. All right, Mr. Quintana, you are excused and best of luck to you, sir.
Your Honor, may I be excused, please?
Yes.
Thank you, Judge.
Thank you, Deputy. Sorry for the delay, sir.
No problem, ma'am. Have a good day.
You too. No need to apologize. Thanks, Siri. Anyway, okay, we have an Alicia. Oh, I'm sorry, Rhoda Apaya. I'm sorry.
Yes, good morning, Your Honor. I'm here on CL-14-3693-I. This is a National Collegiate Student Loan Trust. versus Victoria Guerra. I don't think that the opposing counsel is here. We'd like to request a continuance on this matter, Your Honor.
Okay. Can you please file an order resetting hearing on your bench trial, and we'll go ahead and get that set for you.
Okay, we'll do that. Thank you so much, Your Honor.
You're
Judge,
welcome.
if I may, Ms. Cardenas on the line, that's for this case.
Pardon me, Judge, may we be excused?
Oh, yes.
Thank-
We'll see you
thank
tomorrow.
Yes, ma'am.
Thank you, Your
Okay.
Honor.
Alicia Cardenas, can you hear me? Alicia Cardenas?
Yes, I'm here. Good morning, Your Honor. I'm here.
Good morning, ma'am. Okay, so the attorneys are asking for some time. So they're gonna reset this matter and they're gonna file a document. Now, let me ask you, Counselor, do you have Ms. Cardenas's information in order to include her on the order resetting hearing?
I do not, actually.
Okay. Ms. Cardenas, do you have an email address?
Yes, I have it.
Okay, what is your email address?
It's Regia Alicia, REGIALICIA 2007 @yahoo.com.
Wait, you said she is here for Victoria Guerra, that case?
No, Ms. Cardenas is one of the pro se defendants.
Oh, okay, on the same matter.
Yes.
Okay, I did not catch the email. Is it, she said RED as in dog?
No, it's REGIALICIA 2007 @yahoo.com.
Excuse me,
Okay.
I already filed a motion for continuance this morning.
Okay, we're gonna grant the they're also asking for more time.
Yes.
So we're gonna go ahead and do that. So she's gonna file an order resetting hearing this. And then she's gonna include you also in there. Now, Ms. Cardenas, are you gonna continue to represent yourself?
No. At this time, I am planning to look for a lawyer to represent.
Okay. So I will tell you that we probably won't be hearing this until January or February because we are very, very, I already put too many cases for November and December. So just so you also know, Counselor, that I'm
Yes,
pretty
ma'am.
stacked for the last 2 months, for the next 6 weeks. I didn't even realize we're down to that. So this probably will not be heard until late January or February, just so you know.
Okay, that's fine. So just go ahead and file an order setting hearing and then notice Ms. Cardenas and then the other defendant and then.
Yes.
Okay.
Okay.
But what date would that be for the reset of the hearing?
You need
don't
to
know.
file, I won't know. We're gonna look at the calendar as we're getting those order resetting hearings.
Okay.
So, but I do know that it will not be until late January or sometime in February.
Okay, Your Honor, that's fine. Thank you. That's the only matter I had before the court. May I be excused?
Yes,
Thank you so much. Have a good one.
you too. Ms. Cardenas, you are also excused.
Okay, thank you, Your Honor.
Ma'am.
And so you will send me an email or just?
Yes, they're going to send an email as soon as they send us the paper. And then we're gonna fill out the date. And then they're gonna email it to you.
Okay, that's fine.
Okay?
Thank you. Okay, thank you.
All right, thank you. All right, so we do have a bench trial at 11. So we will be on a break until that time and then we'll take up the rest of the docket. Okay, we're off the record. Counselor, we're off the record right now. We're taking a quick break because we had some settings for 11 o'clock. I'm going to give him a couple of minutes and then we'll get started.
Thank you, Your Honor.
Yes, sir. Okay, Ms. Flores.
Yes, Judge.
All right. Okay, we're back on the record. Mr. Velasquez, what case are you here on?
Good morning, Your Honor. Yes, so I'm here on two cases ending in 19-0469E and 19-6669-I.
Okay, so they're both I cases, so now that they've been transferred. So you're here covering the bench trial for the plaintiff?
Yes, Judge, and before we get on the record, Your Honor, I did want to just let you know, with respect to notice of this hearing, my trial packet, so they send over a trial packet to me and it contains all the documents and so forth. And there is a notice of hearing that was sent to the defendant. The reason I'm bringing it up to you is because it was never signed by the court and it was sent on, there's a certification of service sent on November the 4th of 2021. That is 3 days, well, that was now, would be 4 days ago. And more importantly, there's no notice of Zoom hearing. So I don't know if the defendant has any notice that this hearing was conducted via Zoom, because it just simply says.
What case was that one on? On which one? On both of them?
Yes, Your Honor. They're almost identical except in name and in certified mail return receipt requested number. So it says, just so you know, it says this is to certify that in compliance with the provisions of Texas Rules of Civil Procedure on 11/4/2021, a true and correct copy of foregoing plaintiff's notice of hearing has been served on the following named person by CMRRR, and then it has the number to Mr. and Mrs. Alan Seguda, 715 East Hawk Avenue, FAR, Texas, 78577. And so the attorney of record signed on that. But the issue, again, is just want to be forthcoming with the court. I don't know, I don't see any notice that it was via Zoom and anything like that. And I also didn't see it signed. And it was 4 days ago, so.
Okay.
Judge, if I may?
Hold on. So the order setting hearing that the court signed was signed on November the 5th. So that's not the one that you all, or that, I'm not saying you all, but that, because you, I know, are getting it from them. So that's not the one that they sent out to Mr. Martinez then?
I don't believe so, Judge, and only because you didn't sign it. And it says November 4th on here.
Okay, yeah. So they didn't wait to get the order setting hearing that was sent by the court. All right. So what we'll do is on those two cases, on CL 190469-I and CL 196669-I, if you can submit an order resetting hearing of the bench trial on both of those cases, and we'll get them set for you, and we'll make sure and let them know that they need to wait for the one that is sent by the court that's signed by us.
Yes, Your Honor.
I won't have a date for you right now, Mr. Velasquez, but they'll submit it, and I will tell you that we're not able to set those probably until the end of January or sometime in February.
Yes, Your Honor. And just so I could relay back to them, in terms of, you know, in this new hybrid world we live in, do they need to include that this is going to be held via Zoom? Is there special language that the court is requiring, or is it sufficient simply just to serve them at their address without any indication that it's remote?
I prefer for it to have via Zoom, but we have had defendants show up and then we'll give them the Zoom link.
I got you.
So if they show up, we give them the Zoom link, but they should put on there, but I'm not requiring it because of the fact that it gets too tedious. So either they're going to show up, or, you know, they call us and then we give them the Zoom link. It's more work on our part, but we just try to leave every avenue open to give a defendant an opportunity to show up.
Yeah, that makes sense. Okay, so I will relay this back to the client, and then we'll get in contact with your clerk to look at available dates for.
Yeah, just submit the order resetting hearing, and the date will come off the bench. Like we'll be the one to give it to them.
Oh, perfect. Okay, Judge, That's all I have for you this morning, ma'am. Be excused.
You certainly may.
All right. Have a wonderful day, Judge. Bye-bye.
Thank you, you too. Okay, the only one that I did not hear from is F 1515-20-9. That's number 14 on the court's docket. Oneida Hernandez and Ruben Hernandez Flores. And I understand that the last time they said that the respondent may be in Mexico. So we'll go ahead and just set that for the next drop docket. And that concludes this morning's docket. Okay, we're now off the record.